I'm Kate Sheridan, the co-chair of the LIV Workplace Relations Committee, and it's my pleasure to chair this session this afternoon, where we're going to hear from presenters Zana Bytheway and John O'Hagan, both from the JobWatch, who are going to help us navigate through the many issues that are facing employees. So it's my pleasure now to introduce the first speaker, Zana Bytheway. Zana is the Executive Director of JobWatch, an employment rights legal centre which assists Victorian, Queensland and Tasmanian workers. Zana has a Bachelor of Law and Arts and was admitted to practice in 1986. Zana is a qualified mediator, co-chair of the Law Institute's Workplace Relations Committee. She's a board member of the Federation of Community Legal Centres and committee member of the RMIT Legal Practice Program Advisory Committee. She's an advisory committee member for the Wurundjeri Criminal Record Discrimination Program. Zana is also a mentor for many programs, the Monash University JD Mentor Program, Melbourne University Senior Schools Program and the LIV Mentor Program. So please join me in welcoming Zana, who is now going to take us through some of the challenges and options available to employees.
Thank you very much, Kate. Good afternoon and welcome everybody. First of all, I just would like to highlight some of the work of JobWatch to remind you as an employee that you can access this invaluable service. So JobWatch is Victoria's specialist employment rights legal centre. We provide a free and confidential telephone information service to employees. So that's you, all of you out there that need our assistance. There is no great surprise that JobWatch has been inundated with calls, now almost exclusively COVID-19 and JobKeeper related. Basically, our callers are experiencing issues which I believe you during the webinar may be experiencing, or maybe it's your family or friends. And that's why it's really important to be able to relate to those issues. Essentially, employees are calling us about the fact that they're not getting their full JobKeeper payment. Some employees are being asked to increase their hours so that they earn the JobKeeper payment. Others have been asked to decrease their hours so that the employer doesn't have to top up their usual wage. We're also experiencing more calls about requests to take annual leave, and also callers are concerned about their employers not nominating them, failing to nominate them for JobKeeper, which is becoming an increasing issue. I'm not sure why, but it certainly is an issue. So you could be, as I say, experiencing these issues, or your family or your friends. So as an employee, I want you to feel supported. You know that there's somewhere that you can go. There is plenty of information available to you, but today it's about supporting you and letting you know what you need to know about your rights and obligations under JobKeeper. What is the JobKeeper scheme? So remember, it's a temporary, and I emphasise the word temporary, it's a temporary wage subsidy scheme open to businesses impacted by coronavirus. It's designed to support employers to maintain a connection with their employees. Now, this is really important. I don't think this objective of the Act is actually made very clear. It's a really important provision that employers and employees stay connected. That connection is always vital, but never more so vital in circumstances such as these. And that is a very strong objective of the scheme. It basically means that the government is providing eligible employers with $1,500 per fortnight per eligible employee. I need to highlight this because if you as an eligible employee are entitled to the JobKeeper payment, you need to know that you will always need to receive a minimum of $1,500 per fortnight. And if you're not, there's some serious issues. So a minimum payment is required under the JobKeeper. Now, employers can top up that payment. So, for example, if your wage is $3,000 per fortnight, the employer receives the $1,500 JobKeeper, but is required to top up your wage. Now, remember when I said that basically this scheme is temporary, so it starts on the 30th of March and will end on the 27th of September. The Fair Work Act, of course, was amended and the new Part 64C was added. That's the technical aspect of it. The JobKeeper provision started on the 9th of April and will end on the 28th of September. So who is eligible for JobKeeper? So as an employee, how will you know that you are eligible for this scheme? So firstly, you need to have been employed as of the 1st of March. You need to be 16 years of age and over, and you must be currently employed. So that can include if you've been made redundant and if you are on stand down. So on stand down, you are still employed, of course. Australian citizens, Australian permanent residents and special category 444 visa holders are also eligible. Can I point out though here, it's pertinent to point out that temporary visa workers are not eligible. That presents enormous difficulties because this class of workers currently are employed, and if they're not eligible for JobKeeper, the employer may elect to exclude them. That, of course, presents enormous financial hardship because without work, without the capacity to pay for their rent and food, and not being able to return because of travel restrictions, they are stuck here in very dire circumstances. So I just need to highlight that particular scenario. An employee must not be receiving JobKeeper from another employer, and also permanent full-time, permanent part-time and regular and systematic casuals with more than 12 months service as of the 1st of March are eligible. Now, unfortunately, there are those casuals, and a lot of them, that are ineligible. I think yesterday I heard that a casual had missed out by 3 days in respect of the eligibility. So casuals in particular, the nature of their employment is very different. They're employed on a day-to-day basis. So once again, I can only say that it would be beneficial that casuals beyond the 12-month service were included and eligible. You cannot be receiving workers' compensation for total incapacity during this period. So what are the JobKeeper provisions of the Fair Work Act? Well, basically, I just like to think of them as 2 categories. Basically, directions, meaning that under JobKeeper, employers can give directions. Additionally, employers and employees can reach agreements, and they can basically be to change the days and times of work and to take annual leave. The provisions also give the Fair Work Commission new powers, thankfully, to deal with these JobKeeper disputes, which obviously we've seen a kickstart to that already. So in respect of directions, they're called technically enabling directions, but employers can direct employees to work fewer hours or to not work at all, meaning remain at home and not work at all. And this is called a JobKeeper enabling stand down. Additionally, employers can direct employees to change their duties or their location. So this gives that degree of flexibility to employers to direct their staff accordingly in these circumstances. So in relation to the stand down directions, first and foremost, there are safety considerations. There are safety considerations throughout, but certainly they apply to stand down directions as well. One of the key aspects of the stand down directions is that the employee cannot be usefully employed for their normal days or hours of work because of coronavirus. So the real question is, can you, in this present environment, be usefully employed? Can your employer use you in these particular circumstances? If you honestly believe that you can't, then obviously this direction will be valid. Employee must be paid the greater of the JobKeeper payment or any wages earned. I touched upon that earlier. You are entitled to your, if eligible, you're entitled to your minimum $1,500 payment per fortnight. The direction is not operative when the employee is unpaid or unpaid authorised leave. So in addition to stand down provisions, so an employer can direct an employee to stand down, additionally to that, they can direct an employee to change their duties or their location. So once again, another change can be directed. The direction once again must be safe. The duties and the new location must be reasonably within the scope of the business operations. If there are changes to duties, they must be within the employee's skill and competency. You can't suddenly be asked to do something that you have absolutely no skill in whatsoever. The employee also must have any required licenses or qualifications if the new duty requires these to be in place. If it's a change in location, meaning you've been asked to work at a different location, the location must be suitable. And once again, safety is part of that suitability. The employee is not required to travel unreasonable distances. What will constitute unreasonable will be a question of fact based on each case. So what are the rules? So what I like to think of as the conditions relating to directions. So the direction must be reasonable. It must be reasonable in all the circumstances. Now, this is particularly important. The employer must have information at hand at the very beginning, which leads the employer to reasonably believe that this direction is necessary. It's necessary to continue the employee's employment. That is a key aspect of these rules. The direction must be in writing and there must be 3 days' notice. This, of course, can be less if there's agreement to the contrary. Consultation must take place and it's required before the direction is issued. You can't have the consultation afterwards. So before the direction is issued, there must be consultation. Now, provided that these rules are complied with, the employee needs to comply with the JobKeeper enabling direction. So basically, covering off on those directions, can I say that why often employers will say, well, why do I need to know about the conditions or the rules relating to enabling directions? And the reason for that is just because you've been given a direction doesn't mean that the preconditions have been met and therefore the direction is reasonable or meets the other criteria. So it's really important that you as the employee know the conditions or the rules relating to the direction, because you don't have to comply with it if the actual direction doesn't comply with the rules. Often employees think, well, these are the rules that employers must follow, but you need to know them because you need to know that this direction has been given in the rightful way. And ultimately, you will need to follow it if it has. Okay, so beyond the directions, so the employer can obviously provide directions, and provided all the rules are complied with, the employer needs to follow them. The other flexible aspect of the JobKeeper is that agreements can be made between employer and employee about changes to days and times of work. So in these circumstances, an employer may request, so the focus of the language is very different. Before we were talking about a direction, now we are talking about a request, a very, very different scenario. So an employer can request that an employee make an agreement about performing performing duties on different days or at different times. In these circumstances, an employee is required to consider, so need to carefully consider the request and then not unreasonably refuse the request. The agreement must be in writing. These are the technical aspects of it. When the agreement is made, the employer must have, of course, qualified for JobKeeper. Once again, the performance of these duties on the days and at those times, as now requested, must be safe and reasonably within the scope of the employer's business operations. It can't be something completely novel and outside the scope of the usual business. And of course, this is not a mechanism. So an agreement to change the days or times of work is not a mechanism. It cannot be used as a mechanism to reduce you as the employee, to reduce your hours of employment. Okay, a really topical issue at the moment, requests to take annual leave. And of course, we've had the decision of Macready and Village Roadshow theme parks, which has been handed down and very important and significant in this space. So once again, this is a request, not a direction, but a request. So an employer may request an employee to take annual leave, but this is provided that there's always a balance of 2 weeks remaining of annual leave. So you can be requested to take the annual leave. Once again, you must consider and not unreasonably refuse the request. In the Macready decision, of course, it was found that the employee did unreasonably refuse the request. The employer and employee may also agree in writing that you can take twice the annual leave at half pay. So effectively what you're doing is you're extending your annual leave and you're deciding to claim it. Can I point out that while there's requests, if you've considered them and you can't unreasonably refuse them, remember that at the conclusion of all of this, that your annual leave will in fact be diminished. You won't have as much annual leave remaining when eventually you can take your annual leave and perhaps travel overseas. That's a really important consideration, because one of the things I consider is that an employer in these circumstances can stand down the employee, pass on the JobKeeper payment without requiring the employee to erode their annual leave entitlements. So just be cognizant of the fact, be mindful of the fact, yes, you're taking annual leave, but remember at the conclusion of all of this, you will have less annual leave. Well, the Fair Work Commission has new powers. And the new powers, of course, relate to the disputes that may arise under JobKeeper. And they can deal with those disputes by arbitration, mediation, which is available upon request, or conciliation. Or they can make a recommendation or express an opinion. This application can be made by you, the employee, the employer, and any employee or employer organisation. In these deliberations, the Fair Work Commission must take into account fairness between the parties. It can make an order it considers desirable to give effect to JobKeeper, and that may include that it sets aside a JobKeeper direction, it may substitute a different direction, and it may make an order that it in fact considers more appropriate. Of course, everyone needs to remember that, like all these provisions, they are temporary, and same applies as to the effect of this order. This order is temporary and will have no effect post the 28th of September. So the dispute provisions under the Fair Work Commission, to recap, can be about the enabling stand-down direction. It can be a direction about duties, a direction about the location of work. It can be about a request to make an agreement about the change of days and times of work, and a request about for an employee to take annual leave. And it also includes a request to engage in secondary employment and a request for training and professional development. Thank you very much.
Thank you, Zana. I was just going to say, before we move on to John's presentation on the stand down, can I just clarify with Macready? As I understand it, what occurred in that case was that the Commission overruled the employee's objection and ordered that she take 1 day's annual leave. Is that correct?
Yes, that's right. Yep. Yes, so essentially, look, and can I just reiterate that each case turns on its own facts. I mean, there were particular circumstances relating to this, and part of it was the way that the employee dealt with the matter, and also basically that there were there were leave opportunities available, and she hadn't actually had the leave approved. So I know this decision has been made, and her request was considered unreasonable, but that doesn't mean that that will be the case always. It may, in fact, because of different circumstances, there may be, in fact, a different outcome.
Okay, thank you. So John O'Hagan is the next presenter to take us through some of the other options that are available. John's interest in industrial relations began in the late 1990s when he became the union delegate of the MEAA at the Circus Oz, where he was a musical director. John's admitted to practice in the Supreme Court of Victoria and High Court of Australia, and advises and assists and represents employees to enforce their rights under the Fair Work Act and anti-discrimination law. In his work at JobWatch, he's really in the firing line, I guess, having supervised the JobWatch telephone information service, and has witnessed firsthand the immediate effects of COVID-19 pandemic on Australian workers. So the service has provided information to the public on the JobKeeper scheme from the moment that it was announced. So John, you've obviously got a significant degree of recent experience here, so I will let you take over and talk about some of the other issues that arise and options that are available to employees.
Thanks very much, Kate. Thanks, Zana. So I want to talk first about stand down under Section 524 of the Fair Work Act, as opposed to stand down under a JobKeeper enabling stand down direction. This is relevant to a lot of employees because, for a start, many employees were stood down already before JobKeeper came in. Even employees who are currently covered by JobKeeper were often stood down to begin with already. And also for that very large number of employees who are not able to benefit from JobKeeper, where the employer hasn't applied for JobKeeper or hasn't nominated those employees. And we are getting a lot of calls on the telephone information service at JobWatch from people asking about stand downs. And in fact, in many cases, simply accepting the information provided from their employer that they are in fact stood down. So I just want to talk about the situations where that's lawful. When are stand downs under the Fair Work Act lawful? So I just wanted to distinguish between the JobKeeper stand down. They are only authorised, the JobKeeper stand downs under Section 789 GDC, where there are changes to business attributable to the COVID-19 pandemic or to government initiatives to slow the transmission of COVID-19. So that's narrow in one sense, in that it has to be because of COVID-19, but it's broader in another sense, in that it's because of any change to the business that's attributable to COVID-19, as opposed to a Section 524 stand down under the Fair Work Act. So this is the traditional stand down that's been available for a long time. And that is available where the employee cannot usefully be employed because of a stoppage of work for any cause for which the employer cannot reasonably be held responsible. But I do just note that the way that provision is drafted, if there is a provision in an applicable enterprise agreement or award that also deals with stand down, then that overrides the 524 stand down. What the cases tell us about Section 524, and this is Deputy President Gostinik in that case there, with the citations right there on the slide, that there needs to be a temporal connection between one of the circumstances arising and the standing down of an employee because the employee cannot usefully be employed. The words "because of" in Section 524, subsection 1, are used to indicate a causal link between the occurrence of the circumstance and the absence of useful employment. So what that means is that it's the stoppage of work itself must be the direct cause of the stoppage of work must be something beyond the employer's control. So that would not include, in general, a decision by an employer that it's uneconomic to keep trading, even if the reason for the economic change is beyond the employer's control. What that means is that, in general, businesses that are ordered to close or who literally physically cannot trade because of COVID-19 could likely invoke Section 524 to stand down their employees. And of course, obviously what that means is they're no longer legally obliged to pay their employees. The stand down is effectively a suspension of the employment contract for the duration of the circumstances that are causing the stand down. In contrast to that, businesses whose operations have simply become uneconomic due to COVID-19 may not be able to stand down their employees under Section 524 because in those circumstances it's a decision made by the employer to stop work and not COVID-19 itself that has actually directly caused the stoppage of work. So a lot of our callers at JobWatch that are telling us they've been stood down, not under JobKeeper, but just under the Fair Work Act, or in some cases they're just telling us they're stood down without any particular details, but it's not under JobKeeper. I anticipate that there might be quite a bit of litigation on this topic as to whether these stand downs have all been lawful. Because in many cases people are simply being stood down because of slackness of trade. We're getting car dealers, for example, who are not selling cars because people aren't buying cars and they're just standing down their employees. And I wouldn't have thought that that's going to meet the requirements of Section 524. So the Fair Work Commission already has power to arbitrate in stand down disputes under 524. That's a Form 13 as opposed to the 13A, which is the form you use for JobKeeper disputes. So they've kept the naming consistent there. So what happens when an employee is unlawfully stood down, if they're purportedly stood down under Section 524, but it's actually not law? So if the employer is not paying the employee's wages, obviously that can give rise to a claim for underpayment of wages. If the employer persists in not paying the wages, the employee may be able to argue that they've been constructively dismissed by the employer's breach of the employment contract and their failure to pay the wages. And obviously, what the employer probably should be doing in these circumstances where they are unable to economically continue with employment, but a stand down is not available to them, is to make the employee redundant, which brings me to the issue of redundancy in relation to COVID-19 and JobKeeper and so on. So we already have a case which was quite early on in the piece where JobKeeper became available, Australian Municipal Administrative Clerical and Services Union and AusScript, which I'll call AusScript. In that case was not about unfair dismissal or JobKeeper. It was about whether the case was brought by the union about whether the employer had satisfied the consultation requirements in the enterprise agreement that applied in that case. It was found that the employer's failure to consider the availability of JobKeeper as an alternative to redundancy meant that they had failed to satisfy the the consultation requirements in the event of redundancy. That's very interesting. I'll just come to why in a minute. But and also we have another case, Worthington Industries, where the employer was applying to reduce their liability for redundancy pay because of their inability to pay, which they can do under Section 120 of the Fair Work Act. And again, their failure to consider the availability of JobKeeper as an alternative to redundancy meant they weren't able to be granted that reduction in their obligation to pay redundancy pay. But where this is interesting to us at JobWatch and other people in this area is that the effect on genuine redundancy. So that decision in AusScript does suggest that the alternative, the existence of JobKeeper as an alternative to the termination of employment could be relevant to future unfair dismissal claims. So if someone is dismissed and the employer, obviously with unfair dismissal, as people will be aware, threshold question, which you could loosely call a defence against an unfair dismissal claim, is whether the dismissal was a case of genuine redundancy. Genuine redundancy is defined, as it says on the slides there, where there are three limbs. Firstly, the position is no longer required to be done because of operational changes. Secondly, it would not be reasonable to redeploy the employee elsewhere in the business. And thirdly, the consultation requirements in an applicable award or enterprise agreement have been complied with. And if any of those three limbs are missing, then the inquiry moves on to whether the dismissal was harsh, unjust, or unreasonable. So the decision in Ausscript does suggest that where JobKeeper is available, it's going to be harder for the employer to argue that there's been a genuine redundancy because, for a start, they may not have satisfied consultation requirements, the third limb, and which is also goes to the related question of whether it would have been reasonable to redeploy the employee making use of JobKeeper. So that will play out probably in future for dismissal claims, for dismissals that have occurred during this period. I just wanted to move on to the general protections under the Fair Work Act. The new JobKeeper amendments to the Act have added a few new workplace rights, and just for the avoidance of doubt, Section 789GY adds to the workplace rights that are already protected under Section 340 of the Act, Section 789GD, which is the wage condition, that is the obligation of the employer to have already paid at least the $1,500 per fortnight or the employee's entitlements in relation to work performed in order to receive the subsidy from the government. So if they haven't done that, they can't receive the subsidy. That's regarded as a workplace right for the purpose of the general protections. Also, the right to agree or not to agree to JobKeeper requests, and the right to make JobKeeper requests. That's for those training and secondary employment requests that employees can make under JobKeeper. So all of those are new workplace rights for the purpose of general protections. And what that means is where any adverse action is taken against the employee because they have those rights, because they propose to exercise those rights, or where there is any pressure or influence applied by the employer on the employee to exercise or not to exercise any of those rights. And the distinction with general protections is even if there is a genuine redundancy in play, if the person is selected for redundancy or otherwise dismissed because of those reasons, and even partly because of any of those reasons, that's unlawful under the general protections. So there's some existing protections under the general protections as well that are relevant to COVID-19. I've already mentioned the coercion provisions there, where an employer is trying to persuade, pressure, or otherwise force an employee into exercising or not exercising a workplace right. And another one that we're getting quite a lot of calls about actually is misrepresentation, where the employer is telling employees that they need to agree to certain changes to their working conditions in order to receive JobKeeper, and that those kinds of representations by employers could give rise to claims under the general protections. Temporary absence due to illness of less than 3 months, so where people are not able to attend work. It's an interesting question whether quarantine falls into that category, where it's not known if someone's actually ill, but the absence is due to the possibility of illness or the risk of illness. As far as I know, that hasn't been tested, but that's another interesting question that might arise out of these circumstances. And then obviously the discrimination protections in under the general protections under Section 351, if adverse action is taken against someone because of their age, physical or mental disability, family or care responsibilities, or pregnancy, all of those could be relevant, where there's a question of COVID-19 being involved. Although I'm about to come to discrimination law now, but which is a little bit stronger in those regards than the general protections, because with the general protections, there is a defence for the employer if the employee can't fulfil the inherent requirements of a position due to the attribute that is protected. And so, as I was saying just then, unlike the general protections, there are positive obligations imposed on employers by discrimination law, and two significant examples of that, the obligation to make reasonable adjustments for employees with disabilities. And those reasonable adjustments means adjustments that are that do not impose an unjustifiable hardship on the employer. So that's quite a high bar. It's not just a matter of whether the adjustments are inconvenient. Another obligation is to accommodate carer responsibilities, which is not in all jurisdictions, but it's certainly the case under the Equal Opportunity Act in Victoria. And there's a sense in which the obligations under discrimination law can be imported into other jurisdictions. For example, where if someone is dismissed for an incapacity to perform the inherent requirements of the job and an unfair dismissal claim is brought, it may not be a valid reason for termination if the employer has not, in making its determination that the employee can't fulfill the inherent requirements of the job, if they haven't turned their mind to making the reasonable adjustments that they're obliged to make under disability discrimination law. And a couple of examples where we've had a lot of calls at JobWatch is about people who have additional care responsibilities now because the schools are closed, and the employer is now directing them to return to work now that JobKeeper's available, and the disputes arise about whether the employee is required to go back to work and is able to go back to work because of those additional care responsibilities, and what obligations the employer has to make accommodation those responsibilities. And similarly, where people have particular health vulnerabilities that make them more vulnerable to COVID-19, to what extent the employer has to make adjustments now when they're asking them to return to work, subject to anti-discrimination law, as well as the general protections and other rights under the Fair Work Act. I just wanted to talk a little bit about occupational health and safety considerations. Not going into a huge amount of detail here, but Section 789 GZ also expressly provides that the JobKeeper amendments operate subject to any Australian law as far as it deals with health and safety obligations in employment or workers' compensation. So basically it's just saying that the occupational health and safety law still operates unchanged. Under occupational health and safety law, for example, the Work Health and Safety Act 2011, certain persons, including employers and employees, have duties. And when a person has a duty under that law, those persons have to do whatever is reasonably practicable to ensure health and safety, and the legislation doesn't spell out the nuts and bolts of precise steps that must be taken, but they do. There is some guidance in Section 18 of that Act as to what the type of process, the risk analysis process that must be engaged in. So it mandates taking into account, I'm quoting now, and weighing up all relevant matters, including A, the likelihood of the hazard or the risk concerned occurring, the degree of harm that might result from the hazard or risk, C, what the person concerned knows or ought reasonably to know about the hazard or risk, and ways of eliminating or minimising the risk, and the availability of suitable ways to eliminate or minimise the risk, and then also obviously the proportionality of the cost involved in taking those steps. So that's the kind of analysis that an employer, for example, would be obliged to undertake in order to satisfy their obligations under that legislation. And my understanding is that there's model legislation which is mirrored in each state as well. So that would suggest, to me at least, that infection control guidelines, social distancing and so on at work would now be relevant to employers' occupational health and safety obligations. Employees have rights at common law and also under the Occupational Health and Safety legislation. For example, Section 28 of the Work Health and Safety Act, I've gone back too far now, to refuse unsafe work, because under Section 28, the employee also has a responsibility for their own safety at work. So working from home obviously is a big thing at the moment. We do get a lot of calls about whether the employer can both require me to work at home or and obviously it may be a lawful and reasonable direction to work from home, especially where this is done to comply with occupational health and safety law. The JobKeeper directions, which Zana has already discussed earlier, may require someone to work in a different location, provided this is safe, and obviously a direction like that may include a direction to work from home. Work cover still applies when working from home. The workplace can include a home workspace, provided that the employer has directed or consented expressly or impliedly for the employee to work from home. And the employer still has obligations to take steps along a similar through a similar process to what I mentioned before, to ensure that home workplaces are safe. So that might involve just making sure that employees are taking all the right steps to make sure that their home is safe. Obviously, legal questions and uncertainties are going to arise in terms of the limitations to that, and at what point work and private activity changes from one to the other at home. Apparently, if you take a bathroom break when you're working at home, you're covered. But if you stop working and start playing with your dog or something like that, it probably isn't. But there's a potential for a lot of grey area there. So the other side of that coin, obviously, is where the employer is requiring attendance at the workplace. And on the JobWatch telephone service, we've had a lot of calls from people who are being required to work and have strong reasons not to want to do that. There's a number of ways that can be addressed. Under the Fair Work Act, there's the right to request flexible working arrangements for parents and carers, among others, people with disabilities, people 55 and older, and people experiencing family and domestic violence. There are other reasons that people can make that request, but those four in particular seem to be relevant to COVID-19 and the associated measures. So that right to request flexible working arrangements under the Fair Work Act, the request is made, the employer must provide a written response. But unfortunately, and that response must be, they can only refuse on reasonable business grounds. But the particular provision that requires reasonable business grounds in the Fair Work Act is not a civil remedy provision, which means there's no remedy available. So it's unfortunately not enforceable. So the requirement to provide a written response is enforceable, but if that response does not disclose any reasonable business grounds, then that part of it's not enforceable. You can ask the Fair Work Ombudsman to assist you with that, to try to mediate it, but beyond that, it's not really enforceable. However, under discrimination law, that's again a little bit stronger. The employer's obligations to make reasonable adjustments for disability and to accommodate care responsibilities, if that's available in an applicable jurisdiction, they may give the employee some assistance in a circumstance where they don't wish to attend the workplace.
All right, thank you.
Yeah,
thank you,
question.
John. So can I just recap on a couple of things that are available to employers? Because obviously both of you have covered a lot of ground, but from an employee perspective, clearly there's an opportunity to challenge JobKeeper directions where JobKeeper applies. So there is that dispute application process through the Fair Work Commission that people can use. Obviously that doesn't cover the question about eligibility or, why aren't I getting it? So, but it's only in relation to those enabling directions and as we've seen, other requests that can be made, such as the annual leave type request. Then separate to all of that, employees still have access to unfair dismissal remedies should they fall within the eligibility for that. They can also take on general protections complaints and seek recovery for underpayment through unlawful stand down. Is that pretty much what we're saying at the moment from the presentations?
We are. All those legal options and all those remedies, Kate, as you've pointed out, are available. But I think the reality in life is that workplace rights are only as good as the ability to enforce them. And so we have found at JobWatch that given this huge power imbalance at the moment, where workers are desperate to keep their jobs, they will in fact agree to requests and take directions in circumstances where they may not ordinarily have to, because they want to, as I said, keep their jobs, and also they want to do the right thing by the employer. They do understand that times are tough for their employer, and so I think it's an opportune time to urge employers and employees to reflect very seriously about this employment relationship that they have, especially in a time of crisis. It is the time for open communication and honesty and support of each other, because ultimately going to the Fair Work Commission isn't the way to deal with matters. In an ideal world, the employer gets the benefit of their wonderful employee and the employee retains their job.
Could I just add something to that too? I think it's very important for employees to realise in the present circumstances that they don't need to agree to permanent changes to their employment conditions. I think that's very important, because a lot of the JobKeeper directions and requests are available to the employer temporarily to get through this this period. But we are getting a lot of calls again on the telephone service from people who have already, unfortunately, and it's too late once they've done it, they've agreed permanently to changes to their employment contract. And some of them will, I think, possibly believe that it's only temporary, but that's not the agreement they've made. And they may find that when this is all over, they're stuck with those new conditions forever. So if you haven't done it already, don't do it.
That's a really good point, because these provisions are, and as we know, the JobKeeper only goes from, I think it was from the 9th of April to the 28th of September or thereabouts. So those directions are very, as you say, they are very temporary. There are other provisions, however, under awards and agreements that might have application as well. And I think one of the other things that we're starting to see, and maybe you've had inquiries about this, is that wage and a couple of the enterprise agreements that I've seen have had wage applications to either vary agreements and stop wage increases from going through. So that's another issue that people might be experiencing. But can I now turn to some of the questions, and we're now seeing too some of the questions that are coming through through the chat box are particularly interested in when people are coming back into the workforce, and how to manage the social distancing when they're required to come back. And I think this is a balancing act between being asked to come back to work, which is obviously a lawful direction, but then balancing that with, from a health and safety perspective, what would you expect an employer to provide or give assurances about? And I think the question actually came in the teaching environment and the teaching setting, where, you know, children obviously may or may not be carrying COVID, and it's probably community wide. So I just wondered whether or not you could respond to that. I think, John, that's a question that you were going to pick up on.
Yes. So I think I already touched on, when I was talking, just touched on OH&S issues earlier. I talked about that analysis on the risk analysis that needs to be undertaken by persons that have obligations under occupational health and safety law. So and the employers include to undertake that analysis to satisfy their obligations. So and I think the questioner was asking about the availability of information about the testing, so that they could, the employers could make a good decision about, an informed decision about what measures they need to take. If you had good demographic information about who's getting where the infections are occurring, if there's demographic correlations there with infections, if there are infections arising in particular circumstances. The availability of that information would obviously really help people to make those decisions. And so if there are legal restrictions on the availability of that information, then obviously as the legislation puts it, one of the considerations is what the person concerned knows or ought reasonably to know, and that's going to go to that if they don't have access to that information. But whether that then is able to be taken a step further and to use that as an argument that a public authority that holds that information is required to release it is another question altogether.
Yeah, there's all privacy issues, I guess, as
yes.
well.
So yes, so there's serious privacy issues, obviously, with releasing individual information about infections, but de-identified demographic information may not have that problem. But it's very difficult to make a public authority, to force a public authority to do anything that's not required by legislation to do. So if you've got a situation where, I don't know, say the Education Department or the health authorities have information that the Education Department would like to get, they're probably not required to do that. There's not going to be legal liability if they don't. So the liability, for example, under the Wrongs Act, really is limited for public authorities. For an act of a public authority or an omission to be wrongful, it has to be so unreasonable that no public authority could properly consider it to be unreasonable. So in terms of holding any public authority liable for failing to release that information, that would be, it's not really my area, but my understanding is that it would be very difficult to do that. But as a matter of policy, and this is for the policymakers, it would be obviously extremely desirable if that preferably de-identified information could be made available to the people that are making decisions in education about how to go about restarting the schools.
So number one question here in terms of the JobKeeper direction, I think you covered this off with the Macready example. The answer to that was, well, we've got some precedent now that enables an employer to give a direction to take annual leave, and in that case it was 1 day a week. And as you mentioned before, Zana, it's very much dependent upon the facts, and I guess we don't know whether or not Macready matter may in fact be appealed, so who knows where that might end up. Do you have anything further to say about that though, Zana?
Yes, look, I think Kate, we've touched upon it and you summarised it perfectly well. But just a reminder, of course, that it is still a request, and that whole question of unreasonably refusing is a question of fact, and so it'll be determined on that. So it's just a reminder, it's not a direction, it's a request. And also a reminder that at the conclusion that your annual leave will be diminished. You need to be conscious of that as well.
Excellent. Now the scenario 2, which seems to be a common one, certainly having spoken to a member of the Commission about people missing out on JobKeeper payments.
Yes.
What are the options there?
Oh, Kate, I'm really staggered by this. I'm very surprised about the number of calls we're receiving about this issue. From my perspective, when you nominate an employee, the employer and the employee benefit. So it's hard to imagine why there isn't the nomination done when an employee is eligible. But it is a reminder that employers are required to nominate all eligible employees under the one-in, all-in rule. So why I can't understand it, because number one, as I say, it's a legal requirement, so they need to do that. I think that employers feel that they are at risk potentially. So if they do nominate an employee and they're later determined by the ATO to be ineligible, there may be a recoverable overpayment to the employer. I think that is one of the reasons they're a bit nervous about overstating the eligibility of their employees, for fear that in fact they then will not be eligible. I think there is also some sort of a psychological barrier at play as well. I think employers are thinking, well, I've stood someone down, they're not doing any work at all, to pass on the JobKeeper payment to them, it doesn't sit right, it doesn't appear to be the intention of the scheme. And of course, once again, a reminder that that is totally incorrect. But we've been suggesting to employees, because the problem is for employees when they haven't been nominated, they do not have individual standing. So it's an employer's decision not to nominate, and they do not have individual standing at the ATO. That's only a standing that the Commissioner of Taxation has. So that's a real problem there. So we've been addressing this problem by telling callers that in those circumstances, they can perhaps nominate themselves to the ATO and perhaps attach a statement advising why they should be in fact eligible. In addition to that, we've actually sort of said, well, the employer and the employee can agree to let the ATO determine eligibility. So that's another option. Although not strictly applicable, we have been advising callers to file a Section 13A with the Fair Work Commission to actually have the dispute arbitrated, possibly on the basis that the employer has not complied with the wage condition. So we're not saying that this is necessarily going to be a successful avenue, but in the absence of not having standing at the ATO, then this is another vehicle by which they could have that addressed.
Yeah, and unfortunately, I think we've seen some decisions just in the last couple of days that have been really clear about eligibility, unfortunately. So it is, you know, and from the Commission's own information, they're out of the hundreds of applications that they've got, there's only 25% effectively that they're dealing with, and which leads you to think, I don't know where people will be going. John, are you happy to answer this next question about people learning from home, students learning from home, and whether or not they can continue to do that? I guess there's a lot of parents who have been sort of forced into that situation to work from home.
Yes, and I think we've probably already covered this to some extent in what I was talking about before. So is it lawful for an employee to work from home? Well, there's nothing inherently unlawful about working from home. And of course, if the employer gives permission to do it, then that's fine. But then then there's no problem if the employee wants to work from home and the employer allows it. But if the employer is requiring the employee to come to work, and the employee has reasons such as additional care responsibilities, yeah, or which would include this homeschooling that has to be done at the moment. And you know, I must say, everyone's even at my place. That's it's really an additional workload on the household. But all those things we talked about before, lawful and reasonable direction, obligations, and relevant to whether it's a lawful and reasonable direction are the legal obligations of the employer.
And they could make and they could make that direction as the request, as you said, given that they've got additional family and carer responsibilities, and it would be unreasonable for the employer to reject that on reasonable business grounds, you would think.
Yeah.
Okay, we're sort of moving.
Just adding to that, of course, just a reminder in terms of that, yes, it's a lawful and reasonable direction to return to work. However, all the occupational health and safety aspects need to be considered in this environment. And also there will be state orders and state directions about such matters as public transport. So when we're talking about that ability to return to work, we have to, as I said, focus on the occupational health and safety issues and what are the current government directions that are at play. All that will be very, very relevant.
Yes, that's absolutely spot on. So in terms of the next question, really it's about stand down. I think to some extent, John, you might have already covered this, where people could have been stood down and
yes.
This is obviously outside JobKeeper or pre-JobKeeper.
So yes, right. I think I've already covered it, but this question is more specifically about whether they properly considered the useful, whether they can usefully employ the employee elsewhere. That's like the first part of that question of whether there's been a stoppage of work, whether they can't be usefully employed because of a stoppage of work for which the employer cannot reasonably be held responsible. So that's that very first question, which I didn't deal with earlier, about whether they can usefully be employed. So yeah, again, if they haven't considered that question, it wouldn't be a lawful stand down under Section 524, and I think we've already dealt with the consequences of that.
Okay, thank you. So just in relation to some of those measures that an employer might take, there's been a little bit of debate about this, and probably more generally in the community, particularly with the COVID tracing app. And separately, it seems to be common that it's acceptable. I've seen some footage of teachers or schools doing the temperature checks. Can you make some comments perhaps on this last question?
Yes, yes, certainly. So temperature checks, I mean, are lawful, particularly obviously in this environment. It's almost essential because we obviously don't want the passing on of the virus. So they are lawful, and in general a requirement to undergo a medical examination in order to comply with occupational health and safety law is lawful, and it would be considered a reasonable direction. The Attorney General has made it clear, however, recently that employers may not require employees to use the tracing app, and there may be penalties, I think fairly severe penalties doing so. I think it's about $63,000 and jail as well. So these are the considerations at play when you're asked to use the app, and but obviously, as I said, temperature checks and those usual medical examination requirements are perfectly lawful.
Okay, now I just wanted to turn to, if we're happy to stay on the line for a few more minutes. So there's a couple of questions that have come through. John and Zana, I'm not sure if you would like to pick up this question about the 1,500 subject to, is the 1,500 JobKeeper payment subject to PAYG withholding, or is it net of tax?
So yes, I can. So in terms of the $1,500, it'll be subject to tax. So that'll be the gross amount, and then you're taxed, and then you'll get the net amount. I think just from experience, it may obviously depending on the taxation circumstances, but you may be netting about $1,300 or thereabouts.
Yes, and now just in terms of some of the other questions, I'm just looking at what else might be easy to answer. Where the JobKeeper payment, I'm looking at where the JobKeeper payments are more than an employee's usual hourly wage. Is it lawful for an employer to request the employee work additional hours?
Well, yes, I can take that as well, because I've covered off on that hopefully, but obviously not clearly enough. But no, essentially, you know, you've basically been contracted to work certain hours, and let's give an example. You've been working two days per week, and as a consequence, you get your $1,500 per fortnight for those 2 days a week. An employer cannot then say, well, look, we're going to increase your hours now so that you can actually earn your JobKeeper payment, meaning make you work the extra hours so that you get your JobKeeper payment. You cannot increase those hours.
Presumably that's for a casual or a part-time worker. Can you see that there might be a situation there where it was appropriate if they had the work to do?
Well, in terms of if it's appropriate and they've got to, and there is the work to be done, it'll have to be dependent upon, of course, the circumstances, but not everyone can increase their hours. For example, some people have health issues, so they have chosen to work 2 days a week because they have health issues and they can't work beyond those hours. They may, in fact, have carer considerations at home themselves. I have a perfect example. One of our callers, she worked typically 10 hours per week. She had a heart condition. She additionally had a husband at home who was very ill. So therefore she worked 10 hours per week. They were her contracted hours. She hasn't got the capacity then to increase her hours. Not everyone will have that capacity. And of course, if their hours are increased, then they will have to be paid the requisite wages.
Thank you. Sorry.
Can I just add a little bit to that? Also, that there may be circumstances, just leaving JobKeeper aside, where the employer could, an employer can ask an employee to work reasonable additional hours under the Fair Work Act, under the NES, and so, but the employee can refuse if it's not a reasonable request, and that's the case anyway. So that's not really to do with JobKeeper, but there's no particular power under JobKeeper to order someone to work more hours, to direct someone to work more hours. There is one of the requests to change the roster, to change the hours of work, could conceivably be interpreted to mean that increased hours, although I think that section is probably directed at rostering rather than number of hours, but it doesn't exclude the possibility that an employer could request an employee to work more hours and not unreasonably refuse that request. But they can't direct. An employer certainly can't direct an employee to work more hours simply for the purpose of making them earn the payment.
Thank you. Look, I am being asked to wrap things up, so I just want to thank Zana and John very much today for such an informative session. There's clearly a number of other questions that have come through that we haven't had time to answer. However, the panellists will provide answers separately to these questions. And we thank you all very much for today's presentation.